Welcome and thank you for standing by. At this time, all participant lines are in a listen-only mode. After today's presentation, you will have the opportunity to ask questions, and at that time you may press star, then 1 on your phone's keypad to ask a question in conference. Today's conference is being recorded. If you have any objections to this, you may disconnect at any time. And now I would like to introduce your host for today's conference call, Director Mark Pierce, Division of Depositor and Consumer Protection. Sir, please go ahead.
Great. Good afternoon, everyone. Thanks for joining us today for our presentation on the overdraft payment supervisory guidance we issued in November of last year. This guidance is directed to encouraging institutions to monitor the risks of automated overdraft programs and to take actions to mitigate those risks, especially regarding excessive usage of automated overdraft programs. By way of background, last summer the FDIC issued guidance as a proposal and received over 900 comment letters. After issuing the final guidance in November, we continued to receive a number of questions from institutions and their representatives. In fact, by virtue of today's call, I think we have over 4,000 lines open onto this call. And so I hope that through today's call we are able to answer many of your questions, and hope that this call will help you to appropriately manage the risks of automated overdraft programs. In particular, over the past few months, the FDIC has made a concerted effort to gather feedback and concerns regarding implementation approaches to the guidance. We've met with individual bankers, we've met with trade groups, with vendors and consultants that provide payment program services to financial institutions. We've received a great deal of constructive feedback on how banks can manage the risks of automated overdraft programs. Based on these meetings, the FDIC has developed a set of frequently asked questions that we will discuss today, and we will post on our website later this week. We will also answer some questions that we've received by email from individual bankers and their trade associations. Given the number of callers we have, we won't be able to open today's call up for live question and answers, but we do have a lot of questions to go through today. Before turning it over to other members of my team, I want to start off by highlighting 3 themes that underlie today's call. The first is that automated overdraft programs contain significant reputational and litigation risks for institutions. Based on our own research, the vast majority of overdraft fees are paid by a small percentage of bank customers that are using the program as a form of short-term, high-cost credit. 11% of customers overdraft accounts more than 6 times in a year. Based on these recurring fees paid by these customers, we believe that many of the frequent users of overdraft programs qualify for lower cost or more appropriate alternatives, such as lines of credit, linked savings accounts, or affordable small dollar loans. The guidance encourages institutions to reach out to customers that are using programs with an excessive reliance on the overdraft feature to inform them of available alternatives, to ensure that they are aware of their alternatives and that they're able to access them in a straightforward fashion. Guidance suggests ways institutions can do that. Second, the 2010 Overdraft Payment Program Supervisory Guidance is targeted to automated overdraft payment programs. Our research indicates that less than half of community bank institutions operate automated overdraft programs. The traditional banking practice of covering ad hoc payments as an accommodation to a particular customer is not the subject of the guidance. Today's call will provide more information on the distinction between automated overdraft payment programs and ad hoc payments. This distinction is important as the rise in automated payment programs in recent years have fueled excessive reliance on these programs, or on the overdraft feature of these programs, generated an increase in complaints from consumers and attention from consumer advocates, and created the most reputational and litigation risk to financial institutions. Finally, I want to say a word about implementation of the guidance. Most of the questions and concerns I've heard about the guidance as I've met with bankers and their representatives, presume that the FDIC intends to implement this guidance as a regulation or a rule. I want to make it clear that that is not the case. The FDIC does expect institutions to consider the risks of automated overdraft programs and to take steps, meaningful steps, to mitigate those risks. These risks are real and they need to be managed. Our guidance provides some concrete and specific steps to manage these risks, but as you will hear in today's call, institutions have flexibility in developing approaches to address the risks of automated overdraft programs, especially as it relates to following up with customers that are frequent users of the overdraft programs. The FDIC has held in-house examiner training to ensure consistency in our examinations and to reaffirm the guidance as one aspect of the overall examination approach. Now I'll turn things over to Luke Brown, Associate Director for Supervisory Policy in the Division of Depository and Consumer Protection, to talk a little bit more about why the FDIC issued this guidance. Luke?
Thanks, Mark. Good afternoon. Thank you for joining our call. The rest of today's call will involve three folks here at the FDIC. First, I'll give you some background on why we issued the 2010 overdraft guidance. Then Victoria Pawelski, a Senior Policy Analyst in the Division of Depositor and Consumer Protection, will summarize the key elements of the guidance and cover examination issues. Lastly, Michael Briggs, a Supervisory Counsel in the FDIC, our legal division, will take the lead in answering frequently asked questions we received in response to the 2010 guidance. We have received and reviewed a number of questions that also were submitted to our mailbox that was established with respect to the teleconference. Our presentation should answer most of those questions. Feel free to contact us if you have additional questions. Also, you may continue to send questions by email during today's call. Now for some background. The FDIC issued the guidance in the wake of evidence demonstrating a pattern of excessive use of automated overdraft programs by some consumers at some FDIC-supervised institutions. The federal banking agencies previously addressed this issue back in 2005 when they issued the Joint Guidance on Overdraft Protection Programs and recommended that institutions monitor excessive consumer use, which may indicate a need for alternative credit arrangements or other services, and inform consumers of these available options. Since that time, the FDIC has seen continued growth in the use of automated overdraft programs, as well as a continued rise in complaints related to overdraft programs and services. In November of 2008, we issued our study of bank overdraft programs. The purpose of the study was to gather data on the types, characteristics, and use of overdraft programs operated by FDIC-supervised institutions. In addition to shedding further light on the features and costs associated with these programs, the study affirmed the tendency of a small percentage of consumers to rely heavily upon high-cost overdraft products as a substitute for long-term credit. And a small number of customers account for the vast majority of fees collected in overdraft programs. Accounts held by customers in low-income areas were more likely to incur overdraft charges, and recurrent overdrafts were more likely in lower-income groups. We also identified automated overdraft-related risks in our supervisory examination program over the last several years. In addition, we continue to see a pattern of overdraft-related litigation, and various courts have found certain practices in violation of state or federal laws. For example, you might be aware that a large financial institution was ordered to pay more than $200 million to California consumers as a result of their automated check clearing practices that were found to violate California law, and several other lawsuits involving overdraft practices are proceeding in multi-district litigation in federal court. The Office of Thrift Supervision and the Comptroller of the Currency have similarly found that certain automated overdraft payment programs in their supervised institutions violated federal laws. And the Federal Reserve Board addressed particular aspects of overdraft use in recent rulemakings under Regulation E and Regulation DD. Having identified continuing risks related to excessive automated overdraft program use and high fees, as Mark discussed, in August of 2010, we proposed guidance that would assist FDIC supervised institutions in identifying, managing, and mitigating risks associated with certain automated overdraft payment programs. Because this is such an important issue to consumers as well as banks and others, we decided to do something that we don't typically do, and that was to post the guidance for public comment. And we received more than 900 letters covering a wide array of opinions and perspectives and concerns and issues. Among the concerns raised in the letters by consumers were complaints about paying thousands of dollars a year in overdraft fees. Other consumers said they overdraft their accounts by 50 cents or less and were charged fees of $25 or $30 per transaction. Some consumers complained that their banks were processing their transactions, their largest transactions first, which resulted in them paying multiple fees on several smaller items that, if processed first, would have been covered by the money that was in their account. Others expressed confusion about the terms of the overdraft program at their bank. On the other hand, institutions also wrote into the FDIC. And I do want to emphasize this. Many of them made comments about their current programs, and many of them said they were satisfied with the components of their programs and that these programs were already operating consistent with most or all of the components of the FDIC's guidance. In addition, the FDIC is absolutely aware that many institutions have implemented a number of best practices that stand in good stead in terms of consumers and the potential risks at their institution. These products and practices are supportive of the financial needs of the institution's customers, and they mitigate risks. The proposed guidance was drafted in a targeted way to cover some of the more significant issues raised by our study. It addresses overdraft program overuse that may harm consumers rather than provide them with protection against occasional financial errors and shortfalls. The guidance focuses on automated overdraft programs. The supervisory expectations set out in the guidance regarding excessive or chronic use do not apply to ad hoc overdraft practices, which traditionally have been offered by banks as an accommodation to their customers. We understand from our overdraft study that a minority of FDIC-supervised institutions actually offer automated overdraft programs. The guidance describes ways to monitor for excessive use and to provide consumers with information about alternative products that may be better suited for their financial needs. So at the end of the day, what we're focused on is ensuring that institutions are having a dialogue, they're communicating with consumers and saying to the consumer that is involved in excessive use of overdrafts, here are other options, and these options might be better for you, and I want you to understand those options, and then the consumer can make a decision on what they want to do from there on out. The guidance recommends that institutions using vendors to implement or manage their programs keep in mind the FDIC's third-party guidance. And I'd like to close by saying that as the federal regulator of most of the country's community banks, we're well aware of the types of positive customer relationships that community banks are known for. Consequently, the guidance is structured fully consistent with how community banks do business, and we look forward to working with you, and I hope that the information that we're providing you through this call today will be helpful to you for your process going forward. If anyone has additional questions after this presentation, feel free to contact us. Now I'll turn things over to Victoria Pawelski, who will give you an overview of the key elements of the guidance and highlight a few compliance examination-related points. Thank you very much. Victoria?
Thanks, Luke. First, I'll give a quick overview of the guidance. First, the scope. The scope of the guidance is automated overdraft payment programs and not ad hoc overdraft payments or linked lines of credit, which are covered by the Truth in Lending Act and Reg Z. That doesn't mean that elements of the guidance might not be useful in your risk mitigation activities for other types of overdraft payments or practices, though. Automated programs are established programs, often but not always partially or fully computerized, that are used by institutions to determine whether NSF transactions qualify for overdraft coverage based on predetermined criteria. By contrast, ad hoc overdraft payments typically involve less frequent occasions on which a bank employee decides in a specific instance about whether to pay an item or not as a customer accommodation and not on a predetermined or formulaic basis. Note also that the guidance is focused on consumer and not commercial customers. To start, the 2010 guidance reminds FDIC-supervised institutions of existing laws, regulations, and guidance that apply to all types of overdraft programs. In addition to TILA, this includes the Truth in Savings Act and Reg DD, which as of January 1st, 2010, requires institutions to disclose on periodic statements the aggregate dollar amounts charged for overdraft fees and for returned item fees for the statement period and year to date. Additionally, institutions that provide account balance information through an automated system must provide a balance that does not include additional funds that may be made available to cover overdrafts, so that the customer knows his or her true balance and can avoid being charged overdraft fees. It also includes the Electronic Fund Transfer Act and Regulation E, effective July 1st of 2010 for new accounts and August 15th, 2010 for accounts opened prior to July 1st. Regulation E prohibits financial institutions from charging consumers fees for paying overdrafts on automated ATM and one-time debit card transactions unless a consumer consents or opts in to the overdraft service for these types of transactions. And before opting in, the consumer must be provided a notice that explains the financial institution's overdraft services, including the fees associated with the service and the consumer's choices. The final rule also prohibits financial institutions from discriminating against consumers who do not opt in. Of course, the Reg changes don't cover checks, ACH transfers, and recurring debits. Then there's the Section 5 FTC Act, Unfair and Deceptive Acts or Practices provisions, which the FDIC enforces compliance with through its FTC Act authority under Section 8 of the Federal Deposit Insurance Act, plus the Equal Credit Opportunity Act and Reg B, the Expedited Funds Availability Act and Reg CC, and then we remind institutions that they will continue to receive Community Reinvestment Act consideration under the Service or Lending Test for offering lower-cost transaction accounts and credit alternatives, such as small dollar loans and overdraft lines of credit that are responsive to consumer needs, particularly where institutions serve the needs of low and moderate income individuals. We remind FDIC-supervised institutions about guidance that was previously issued and that applies to all types of overdraft payment programs and practices. In 2005, the federal banking agencies issued the Joint Guidance on Overdraft Protection Programs, which covers safety and soundness considerations, legal risks, and best practices in the areas of marketing and communications with consumers, and program features and operation. And many of those common sense recommendations are echoed in the FDIC's 2010 guidance. Then in 2008, the FDIC issued its guidance for managing third-party risk, which is directly relevant for those institutions that use third-party vendors to help implement or manage their overdraft programs. The 2010 guidance further focuses on ways to monitor for and address harmful and excessive reliance by some consumers on automated overdraft payment programs, contrary to their intended use, to provide protection against occasional errors or funds shortfalls. The FDIC regularly provides detailed supervisory guidance to state non-member banks to assist them with managing the risks of certain banking activities, as we did with the third-party guidance and with payday lending. In this case, we updated institutions' existing obligations under applicable laws, regulations, and guidance, and we also provide specific recommendations to assist institutions in addressing risks related to excessive use, and this is in response to the demonstrated pattern of excessive use by a small percentage of consumers in the institutions we supervise. From a consumer protection perspective, Our policy objective is to reduce excessive use of automated overdraft programs, along with repeated, potentially damaging high fees, by encouraging institutions to implement risk management practices so that at-risk consumers understand the true cost of automated overdraft payment programs, are informed of available alternatives, and are given the opportunity to choose lower cost or more suitable products to meet their needs. At a high level, we affirm our supervisory expectation that institutions mitigate safety and soundness, credit, operational, consumer, compliance, litigation, and reputational risks, and avoid violations of related laws and regulations by taking appropriate action. In addition to recommending that institutions give consumers the opportunity to affirmatively choose the overdraft payment product that overall best meets their needs, the guidance sets the expectation that institutions monitor accounts and take meaningful and effective action to limit overdraft use by customers as a form of short-term, high-cost credit. One way to achieve this is by contacting customers who overdraw their accounts on more than 6 occasions in a rolling 12-month period and giving them a reasonable opportunity to decide whether to continue with fee-based overdraft coverage or choose another available and less costly alternative. But this follow-up is not the only manner in which institutions can demonstrate efforts to follow up with customers who exhibit excessive reliance on overdraft programs. In the Q&A portion of the call, we'll cover additional indicators and options towards this end. The guidance suggests limiting fees, such as by instituting appropriate daily limits on overdraft fees, eliminating overdraft fees for transactions that overdraw an account by a small or de minimis amount, and charging fees that are reasonable and proportional to the underlying transaction. It also discusses not processing transactions in a manner designed to maximize costs to consumers. In Wells Fargo and other enforcement and regulatory actions, institutions were found to have unfairly manipulated transaction processing to maximize fee income, and largest to smallest transaction processing is a common factor in several of those types of cases. But our conversations with bankers and vendors suggest a few institutions continue to reorder transactions in this manner. We recommend that institutions promptly honor customer requests to decline coverage or opt out of overdrafts resulting from non-electronic transactions. So this would cover the Reg E gap for checks, ACH transfers, and recurring debits. And of course, all of this should be supported by regular and appropriate board and management oversight and monitoring, regular review of overdraft program marketing, disclosure, and implementation, staff training, and identification of appropriate consumer education resources and methods. We ask banks to consider employing cost-effective existing technology, such as text messages, email, telephone, or cell phone alerts when customers are close to hitting NSF status. And again, we remind institutions using third-party vendors to help manage overdraft payment programs to exercise careful oversight as discussed in the FDIC's 2008 Guidance for Managing Third-Party Risk. As for supervisory considerations, we expect that institutions will have in place approved, responsive compliance and risk management plans, policies, and procedures by July 1st, 2011. Examiners may inquire about your plans regarding the guidance before then. After July 1st, examiners will continue to look at overdraft and NSF payment programs and practices on the whole, relevant compliance management systems, including policies and procedures, and consistency with applicable laws, regulations, and guidance. They'll discuss institutions' risk mitigation efforts, identify risks, and take a closer look where red flags are raised. So in examination terms, that's known as conducting an expanded review. With respect to the 2010 guidance, they'll look at any automated overdraft payment programs and assess whether appropriate compliance risk management systems are established or in process and are addressing excessive use and fees and the risks identified in the guidance. Our examiners have been trained to take a look at an institution's overall program in evaluating whether risk mitigation efforts are appropriate in light of the institution's risk profile, customer relationships, operations model, and given their business justification for a given practice. The 2010 guidance is just that, guidance, and we expect institutions to appropriately consider the risks involved in automated overdraft programs and consider steps to mitigate these risks. In most cases, we expect examiners to have a conversation with the bank about its efforts in light of the guidance. If material compliance management system weaknesses are identified and/or violations of laws and regulations that are found, examiners could use their findings to make recommendations, take formal or informal enforcement or corrective action, or reduce the compliance management system and overall compliance rating. So now Michael Briggs from our legal division will respond to some of the more commonly asked questions we received about the guidance. Michael?
Thanks, Victoria. Good afternoon, ladies and gentlemen. We're going to go through and highlight areas of questions that have come in, both for purposes of today's presentation, but really since the issuance of the guidance. And Victoria is going to ask the question, and I'm going to answer the question, in part just because we don't want you to get sick of hearing my voice. But before we get to that, I do want to underscore a point here about the fact that this is guidance and the specific supervisory expectations that are discussed and that led to the questions we're now going to answer. Those supervisory expectations are going to be considered by examiners in assessing the overall effectiveness of how institutions identify, manage, and where appropriate, take steps to mitigate risks. The guidance gives banks options for how they can address and mitigate risk associated with overdraft payment practices in their own institutions. And so with that, we'll start with the first area of questions, and I'll let Victoria ask me, and I'll answer the question.
Thanks, Michael. So we've kind of covered this already, but it's frequently asked, so let's go ahead and address it. How does an automated overdraft payment program differ from an ad hoc overdraft payment program?
Good question. We covered it a little bit at the beginning of the presentation, but let me just put a little more meat on the bone for purposes of this question. Automated overdraft programs typically rely on computerized decision-making and use pre-established criteria to pay or return specific items. In these cases, there is no case-by-case or little to no case-by-case decision-making with respect to an individual transaction or customer or account. By contrast, ad hoc practices typically involve the exercise of a bank employee's decision-making with respect to whether to pay or return an item. This is done in an ad hoc setting as compared to the automated setting as an accommodation, and it's typically based on the bank employee's knowledge and understanding of that particular customer and account.
So then, do the specific supervisory expectations about customer contact apply to ad hoc overdraft payment programs?
No. As we said earlier in the presentation, the focus of this is on automated programs. The focus of the supervisory expectations is on automated programs. The FDIC's guidance is focused on assisting institutions in identifying, managing, and mitigating the particular risk posed by automated overdraft payment programs. Ad hoc overdraft payments that have been authorized by banks for many years as an accommodation based on specific considerations and knowledge of a particular customer. Those types of practices have not typically and generally been the subject of the type of concerns we've had over product overuse. Consequently, the specific supervisory expectations set out in the guidance regarding customer contact for excessive or chronic users of automated overdraft payment programs do not apply to ad hoc overdraft practices. But as you noted earlier, Victoria, the guidance also is instructive for an institution in reviewing how it handles overdrafts, whether it's automated, ad hoc, or some combination thereof.
But then should institutions monitor and manage risks associated with ad hoc payments?
Sure. While the guidance's specific supervisory expectations relate only to automated overdraft payment programs, institutions that pay overdrafts on an ad hoc basis should manage the potential reputational, compliance, and litigation risks regarding certain overdraft payment practices, such as check clearing practices that are designed to maximize overdraft fees. In addition, the guidance provides updated information on the laws, regulations, and other applicable guidance, such as the third-party vendor guidance, and those are reminders to look at those statutes and guidance for their applicability to even an ad hoc program.
Okay. I guess now maybe we should cover some questions related to excessive use and meaningful follow-up. The guidance states that FDIC-supervised institutions should monitor programs for excessive or chronic customer use, and if a customer overdraws his or her account on more than 6 occasions where a fee is charged in a rolling 12-month period, undertake meaningful and effective follow-up action. What is an occasion where a fee is charged?
An occasion occurs each time an overdraft transaction generates a fee. For example, this would include a per-transaction overdraft or a daily fee for an outstanding overdraft status. As a result, potentially more than one occasion can occur in a day. If 3 overdraft fees are charged as a result of 3 transactions, even if those fees are aggregated, that would constitute 3 occasions. If a fee itself triggers an overdraft, that event would count if a further overdraft fee is charged as a result. By contrast, overdraft items paid where no fee is charged. For example, if a bank pays an item after a daily limit is met on overdraft items paid and the bank waives any additional fees, that would not be included as part of one of those occasions. Thus, if 4 overdrafts occur in a day but the bank only charges 3 fees as a result of a per-day limit on those fees, then that would constitute 3 overdraft fee occasions.
And I'll just add one more question here. Some people have asked whether NSF fees, when an item is returned, whether that's included in the count?
It's not included because in that instance the overdraft is not being paid and a fee is not being assessed for the overdraft. A fee is being assessed because there were insufficient funds and the item has been returned.
Okay. So what is meaningful and effective follow-up for chronic or excessive use, and how can an institution demonstrate that it has made meaningful efforts to reach chronic or excessive users of automated programs?
As was noted earlier, there are different ways in which institutions can take effective and meaningful follow-up. Meaningful and effective follow-up means that the institution has made a reasonable effort to provide the customer with information about alternatives to overdraft payment programs that may be better suited to the individual's need for short-term credit, and a clear mechanism for the customer to avail themselves of those alternatives. The key goal is to ensure that customers are able to make informed choices among available options to them in order to manage recurring needs for short-term credit in their checking account. The FDIC will assess the institution's level of effort to reach customers, the institution's program for providing notice to customers of available alternatives, and the ease with which customers are able to select alternative products. Institutions may employ a variety of techniques based on individual customer profiles and general business practices to contact excessive or chronic users of overdraft payment programs. For example, the institution's overall approach may incorporate contacting a customer by telephone, in person, by mail, or through electronic notifications. Relevant factors include whether the institution first has a regular program to inform excessive or chronic users of overdraft payment programs about the usage and the cumulative cost in a prominent or conspicuous way. Second, does the institution highlight the availability of alternatives to overdraft payment programs that may be lower cost or more appropriate for that consumer? And third, does the institution provide a clear and simple manner that allows the customer to contact the institution and discuss those available alternatives? The institution should be able to demonstrate that it monitors account usage, undertakes programs designed to address excessive or chronic use, and then is able to prove to itself and be able to show to examiners when they're having conversations that it's successfully letting customers know when there's an occasion or a period of chronic or excessive use.
Could you give some specific examples of how institutions can demonstrate meaningful and effective follow-up?
Sure, I'd be happy to. A couple of examples. First example, which is something that has been discussed, included in the supervisory expectation, is what we'll call for today's presentation the targeted approach. And if an institution chooses to operate a targeted approach in terms of contacting chronic or excessive users, the institution would initiate outreach within a reasonable time period, say 30 days, when a customer incurs more than 6 overdrafts in a rolling 12-month period. And that would be the opportunity to discuss overdraft usage and available alternatives to the overdraft payment program. When this period in the 6 and 12 period occurs and the conversation happens, then the count of 6 and 12 is often now referred to in literature in terms of describing that supervisory expectation. That period would repeat each time there's a subsequent period of chronic or excessive use. But we've also heard in talking with bankers and industry groups and others that there may be some customers who would say after the first or second event of having a conversation or some communication with their bank about their chronic or excessive overdraft use that they simply don't want to hear that speech anymore or have that interaction. In such cases, at the consumer's request, the bank can honor and be responsive to that request. The second alternative, which I'll cover very briefly, is some institutions may choose to take advantage of existing regulatory requirements under the Truth in Savings Act and Regulation DD that requires, you noted earlier, Victoria, that the institution on periodic statements must show for the periodic statement period, but also for the calendar year to date, how much that consumer has paid in overdraft charges. They also, if there are any NSF charges, they also have to show that on a statement period and calendar year basis. That information that's already required on periodic statements could be enhanced by targeted information that's directed at those chronic and excessive users, such as you taking advantage of the statement's message box that many banks use for all kinds of purposes to let them know that they are incurring a high amount of overdraft fees, that there are alternatives that may be available, and that they should contact the person who can speak with them knowledgeably and give them the broad base of information about what their options may be. So those are two examples.
Interesting. Why don't we cover some questions on fee limits and maximizing fees? What's an example of an appropriate daily limit on overdraft fees?
Excuse me. Daily limits can help prevent a customer's individual lapse in financial management from triggering a cascade of overdraft fees. And that's why we think it's important to consider imposing limits. And it will be reviewed as one possible element of an institution's overall approach for addressing chronic or excessive use of automated overdraft payment programs. For example, and these are practices that are already at place in some FDIC supervised institutions and others as well. So, for example, some institutions have implemented limits on the number of transactions that will be subject to a fee. An example is no more than 3 per day. Or they may take the other approach, which is we're going to limit the number of overdraft dollar amounts charged, so no more than X dollars per day. There's no specifically prescribed dollar amount or limit, but those are examples of what's an appropriate daily limit on overdraft fees.
And then the guidance also talks about de minimis. So what's an example of an appropriate de minimis overdraft amount?
And by de minimis, we're really talking about that overdraft transaction that's just barely in the overdraft status by some not significant amount of money. Institutions should consider the use of de minimis threshold before an overdraft fee is charged in order to reduce reputational risk relating to charging fees that are disproportionate to the item being cleared and triggering the overdraft. For example, some institutions have implemented de minimis limits whereby they do not charge overdraft fees for underlying transaction amounts of, say, less than $10. And some have declined to charge overdraft fees for transactions of any amount that overdraw the account by less than $10. So those are a couple of examples of de minimis thresholds.
And then the guidance references reasonable and proportional overdraft fees. So what is a reasonable and proportional overdraft fee?
Institutions may increase reputational risk when overdraft fees are significantly greater than the amount of the item being cleared. And so institutions should review the amount charged for the overdraft payment compared to the amount of the underlying transaction that triggered the overdraft and assess whether that amount is reasonable and proportionate in comparison to the amount of the overdraft. An institution should consider de minimis limits to reduce the reputational risk of overdraft fees that are disproportionate to the cost of the underlying transaction as one means of mitigating risk.
Why don't we talk about transaction processing? How can institutions and their third-party vendors work to process transactions in a manner that addresses the risks identified in the guidance?
Good question. Transactions should be processed in a neutral order that avoids manipulating or structuring processing in order to maximize customer overdraft and related fees. Some examples of a neutral order can include the order in which the item was received, the check number or the serial number sequence, or other approaches that are necessary and when based on sound business justification. Reordering transactions to clear from highest item first is not considered neutral because this approach will tend to increase the number of overdraft fees. But by contrast, processing batches of transactions in a random order or by order received is a neutral approach. However, we do caution that the risk factor does increase if institutions arrange the order of types of transactions, i.e. batches, cleared in order to increase the number of overdrafts and maximize fees.
Okay, some other questions. Is an institution required to provide new alternatives to automated overdraft payment programs?
No, they're not. Banks are not required to develop new products in response to our guidance. However, most banks offer some form of short-term alternative, including lines of credit, fixed-term small dollar loans, and linked savings accounts. And the FDIC encourages institutions to provide linked accounts or responsible short-term credit products, such as those offered under the FDIC small dollar loan pilot. Banks are expected to inform excessive or chronic users of overdraft payment programs about alternative products that the institution has available for those customers and to make those programs available to customers that qualify. Such products may qualify for CRA consideration under the service or lending test, as you noted earlier, Victoria.
Okay. Is an institution required to terminate or suspend a customer's access to the automated overdraft payment program if the customer engages in chronic or excessive use?
No. The whole point of having the conversation with a customer is an opportunity to maybe let them know about more available alternatives and to have an informed discussion. It's not to trigger a unilateral decision. Institutions are expected to monitor usage and engage in meaningful and effective follow-up to inform excessive users about available alternatives. However, as discussed in the guidance, a number of risks are associated with chronic or excessive users of automated overdraft programs, including reputational, compliance, safety and soundness, and litigation risk. If such risks are identified during the course of an institution's monitoring oversight of an automated overdraft program, then the institution should take appropriate action to mitigate those risks, as has been the case in the past, as they manage all the risks associated with their business.
The guidance states that the FDIC believes institutions should allow customers to decline overdraft coverage or opt out for payment of overdrafts resulting from non-electronic transactions, such as paper checks or automated clearinghouse transfers. Can you clarify to which transactions this recommendation applies?
What we're talking about here is another example of customer choice and community banks and others doing the right thing by their customers. To promote consumer choice and awareness, institutions are encouraged to permit customers to decline overdraft coverage, i.e. to opt out, for transactions that are not subject to the opt-in requirements under Regulation E for ATM and point-of-sale transactions. So that would mean that we were talking about checks, ACH transactions, and other recurring debits. As part of an institution's ongoing relationship with its customers, the FDIC recommends that institutions consider occasional communication to remind customers about available options to terminate overdraft coverage if that's the choice that they want to make.
And then sometimes we've gotten the question, can a bank just go ahead and have an opt-in policy for all types of transactions?
Well, there are certain regulatory requirements under Regulation E for opting in to payment of overdrafts for ATM and point-of-sale transactions. So we're not suggesting that banks have to go beyond the technical requirements of the law. However, if based on their own customer business profile, if based on their own institution's business practices, they think it would be the right decision for that institution to go further and have an opt-in for all types of transactions, then certainly that would not be something that we would think would be a bad decision for an institution if it makes sense for that institution and its customers.
Okay, how can a small or rural institution provide information about financial education?
We're certainly very aware that small institutions and institutions that operate in rural areas may have limited resources as compared to some of their brethren bankers. So what we would say in answer to this question is, in addition to the educational resources that are identified in the guidance, institutions may want to consider using web-based resources or referrals to reputable nonprofit organizations that are in the business as a nonprofit institution of providing financial education.
Okay. We've talked about ad hoc versus automated, and we've gotten a lot of questions about hybrid programs. So, for example, we've heard that some institutions pay overdrafts up to a certain dollar amount, like $300 or $500, or they treat different transactions differently depending. For example, they consider checks on a case-by-case basis, but pay and don't charge a fee for other types of transactions. So what can you say about these various ways of doing things?
Well, I think that you would need to take the guidance and break it apart and figure out whether it applies to the particular practice that your institution engages in. So, for example, if you have a standard practice where without any individual decision-making, you pay all transactions up to $300 in terms of the account is overdrawn by up to $300, and you just pay those transactions without any consideration, and that really is an automated process. And as such, we would expect that the institution would want to review the supervisory expectations that relate to automated programs and see what steps or risk mitigation efforts they might need to engage in. If at the same time you make an individual case-by-case decision-making with respect to a transaction that's over the threshold, so that you'll pay everything up to $300, but you're going to think about whether or not to pay that next item that's puts you beyond $300, well, that's an ad hoc decision. It involves individual employee decision-making, and we would think that that particular piece of the bank's overdraft practices would not be subject to the automated program supervisory expectation. So if you run a hybrid program, I think it's important just to figure out which piece of it matches up with the guidance in terms of what's focused on the automated programs versus not.
Okay, how about a few more on transaction processing? Would it violate the guidance to process items in a high to low order?
Well, first of all, as we said before, it's guidance, so we're not talking about violations of the guidance. We're talking about part of your overall risk management approach to overdrafts. It is not per se, in and of itself, a violation of anything to process items high to low. However, as has been discussed, and it is clearly evident in the litigation that's going on right before our very eyes, there are heightened risks associated with that approach to transaction processing. It tends to increase the amount of overdraft fees, and it tends to raise the risk profile. At the same time, it's important to take into consideration if an institution employs other risk management techniques that might offset the heightened risk from going high to low. For example, if you process high to low, but you've imposed daily fee limits that really dramatically truncate the ability of the consumer to run up excessive fees, well, that would be a different factual scenario than another one in which there's just no other augmenting to the processing of high to low. But the simple fact of the matter is that in of itself, it's not a violation of any particular law or regulation.
What about items that are received at the same time, since many banks do not have real-time processing but process overnight in batches?
I think we've alluded to the fact earlier that batch processing is a neutral approach to transaction processing. We also recognize that although we're moving closer to real-time processing, we're not there, and not all institutions are there to the same degree. I think you have to go back to the key point, which is, are you reordering, are you taking steps to maximize overdraft fees by the method in which you choose to process transactions? If you're doing that for that sole reason alone, then we believe there's ample evidence that that increases your risk profile.
And then this is just along the same lines, would it violate the guidance? Process must pay items, e.g. authorized point-of-sale items before or with payments that can be declined, like checks.
Again, I think you'd have to look at the individual facts, but if you've got a neutral, legitimate business-supported reason for how you process transactions, that in itself is not necessarily going to raise a red flag, but it does really, though, trigger off what are you doing in addition to these specific transaction processing steps.
Okay. Let's see. Can a third party conduct the meaningful contact and counseling?
Institutions employ third-party vendors to perform and help them deliver a variety of banking services, and certainly if a third party that is particularly skilled at the business of helping consumers understand their choices, then that would be an appropriate use of a third-party vendor. However, as with any other third-party relationship, the compliance responsibility for laws and regulations and to make sure that risks are being managed appropriately, that remains with the institution. So that's not something that can be delegated to the third party. But if that helps a bank meet all those requirements, then it's certainly appropriate to consider using a third-party vendor.
Okay. Yeah, the guidance talked about board oversight. So there's a section of the guidance that refers to oversight by the board of directors. This includes oversight of program features and operations, as well as an annual overview of the overdraft program's key features. Certain institutions have not historically involved the board in this level of detail. Would institutions be permitted to delegate these functions to an appropriate committee?
Well, the board of directors has ultimate responsibility for the institution's compliance with all laws and regulations, and not just with respect to those that relate to overdraft payment programs. While it's certainly possible that it might be an efficient use of resources to have a committee that reviews on a regular and detailed basis what's going on with overdraft payments in that particular institution, because it is an area that, depending on how a bank runs its overdraft payment practices, may raise heightened risk for the institution, then the board at some point needs to be involved and needs to be part of the solution to make sure that that risk, along with all the other risks of running an insured depository institution, are being managed appropriately.
Okay. Do we have to document the discussions with customers, or will a written policy or procedure of how and when those discussions are conducted be sufficient?
We're not, the guidance does not intend to suggest that there is a must-do action step or form in terms of documenting how you're following up. But obviously you need to be able to demonstrate to yourself and to your staff and to your records what you're doing and how you're doing it. And that, of course, leads to having that conversation with the examiner where you can easily show what you do. So we're not prescribing anything in particular as part of this, as this aspect of the guidance, but we feel like you should do what you would normally do in order to easily prove what you've done, and that in addition to your policy statement on that, you've actually got evidence that you're doing what the policy says you're going to do.
How about if a financial institution does not have the technical capability to notify customers when they have a low balance? Could the financial institution offer online access and or telephone access 24/7 for the customer to check their balance? Would this meet the requirement of the regulations?
Well, to the extent that we're talking about letting people know in advance of running into the overdraft, we think that the use of technology to help consumers, avoid overdraft fees when they might want to choose another option is a positive development, and we certainly think that technology can help consumers stay informed and stay on top of their own affairs. It's not a particular requirement to do that, but it certainly makes sense from the institution standpoint in terms of employing technology that may lower its cost, but equally important of reaching out to customers in the way they want to be reached out to. So, for example, many bank customers today prefer to get a text message on their phone about some aspect of their banking relationship. And if that helps them overdraw their account less, then that seems like a positive development and a good use of technology.
Okay. At our bank, we have some customers in our overdraft privilege program, and some are not. For those who are not in the overdraft program, the officer reviews the overdraft list daily and decides if the items will be paid or returned, so ad hoc. In applying the guidance, do we need to apply it across the board to all consumer customers, or only to those customers actually in the overdraft program, particularly with the daily and de minimis limits in the counseling, since we have both a program and decisions made on an ad hoc basis?
I think, as I said, similarly with kind of a related question earlier, I think you have to break this apart. If you're making individual decisions with respect to overdrafts, then that's not an automated decision. That's not an automated process, and therefore, generally speaking, the automated program supervisory expectations would not apply. If you, at the same time, are in a programmatic way and without individual decision-making, putting folks into an overdraft program, then you need to think about the risk of that program. So it would be a little bit of both. Some of it might apply and some of it might not. I really do think, though, that at the end of the day, the first question you need to ask yourself is, are we making decisions on an individual basis, on a case-by-case basis? That would sort of tend to move that decision, that does move that decision into the ad hoc column, versus if we're not making individual decisions and we're simply saying we're paying everything that fits whatever criteria that might fit, that might be rather.
Okay. What do you expect each bank to do to show that they allow customers to decline overdraft coverage? Is it enough to state in product brochures, policies, and welcome letters that they can always opt out, or are you expecting something more?
Well, I mean, we're not prescribing any particular piece of information at this point, but I think you have to accept the reality that if you have information that is really a decision-making that the consumer's making, and that's sort of buried within other information, that tends to suggest that maybe the consumer hasn't really focused their attention on that. And that's to be differentiated from something where the consumer says, I don't want to have overdrafts anymore, I want you to stop doing it, and you can say, okay. So I think that the more direct, tailored approach tends to, I think, underscore that the consumer is really making an informed choice. But again, with all this guidance, what we're really saying is you have some choices and options for how you do what you think is best for you, your institution, your customers, and the risk presented by how you honor and pay overdrafts.
Okay, by allowing our customers to opt out of the payment of overdrafts, including checks, the officers in our banks still have the ability to pay an item on a discretionary basis. Is this acceptable under the requirements to allow customers to opt out of all payments of overdrafts, including checks?
Well, I guess there could be occasions where an institutional would make its choice not to essentially pay an item even though the consumer has opted out of having overdrafts paid. And that might be the right decision for that consumer, but I do think it's important to be consistent with approaches to overdrafts and the payment of overdraft fees generally, and that is to say that if a consumer has opted out and said, don't pay any overdrafts for me, I think they have a reasonable expectation that they're not going to incur a fee for that happening. So while an institution might make the decision because they know that customer or because they know something about the history of that relationship, they might make a decision to pay an item, notwithstanding the fact that the consumer has opted out. I think it would be a surprise to the consumer that they would ultimately incur a fee as a result of that discretion when they've opted out. So I think that that's an area to tread very carefully with.
Is the guidance related to payment order likely to be enforced in an ad hoc situation if the bank does not have overdraft programs?
Generally speaking, the supervisor's expectations don't apply to ad hoc payments. However, as we've said, there may be individual fact cases where even with an ad hoc approach to payment of overdrafts, there are concerns raised with respect to how transactions are processed. And in those cases, I think it's important for an institution to take a look at the guidance, to consider what we've been saying, and to look at the broader environment and what's going on with respect to how transactions are processed, and make sure that they are mitigating the risk even when it's in an ad hoc setting.
Let's see. Can a bank adopt a check clearing procedure for ODP customer items that is different than its check clearing procedure for non-ODP customers? For example, can the bank elect to clear ODP customer items in the order received or by check number and still pay non-ODP customer items highest dollar amount item to lowest dollar amount item order?
As we've said before, we're not prescribing particular processing orders that absolutely are or absolutely are not neutral, and therefore tending to minimize the opportunity for overdraft fees. However, we think that if that is what's happening, that the focus on maximizing overdraft fees should be a warning sign in terms of however method these transactions are being processed.
All right, I think now we're going to give Michael a break and turn to Luke as the moderator on a few questions.
Before I turn the mic over to Luke, this is Mark Pierce again. I can't help but take over the microphone given a chance to do that. I know we're throwing a lot of information and answering a lot of questions over the phone line, and it may be challenging for folks out there to follow all of the specific details, especially as we get into sort of the detailed questions that we've received from bankers around the country on this. And so I want to remind folks that after this call, by the end of this week, we'll post on our website a good number of these questions that we've already gone over today, and then you'll have some written materials to take a look at. We certainly encourage folks to continue to send us questions, and if we find a number of them that address issues that we haven't covered in this call or not covered in our frequently asked questions that we'll post later this week, then we can always supplement those as need be. I think our point here is we're trying to provide as much clarity as we can on ways in which you can meet the supervisory expectations. That having been said, I think one of the challenges we have is making sure that even when we're being specific, we're not creating the implication that this is a rule or that you have to do it a specific way. We're providing illustrations and suggestions that we think might be helpful in managing the risks of these automated overdraft programs to manage the real risks that are out there. So having stolen the microphone for a few minutes, I'll now turn it over to Luke and for a couple more questions.
Okay. We do have a number of questions that have been submitted to our mailbox, so we're attempting to answer as many of those questions as possible to be helpful. So another question is, can a form letter be used for notification to a customer? If so, is there model language? As Victoria and Michael talked about a little bit earlier, what we're looking for here is that an institution may employ a number of techniques based on their customer profile and business practices. So there are a number of options that can be used, including direct contact with the customer, in-person contact, as well as by mail or through electronic notifications to have that contact with the customer. What's important is to have a regular program in place that focuses on excessive and chronic users and focuses as well on the trigger that's in the guides with respect to 6 or more overdrafts in a 12-month period. What also is important is that information is provided in a prominent manner with respect to contacting the institution, and it would be most helpful if when this contact is made that the person that the consumer has the contact with or the discussion with is familiar with various alternative products that would be helpful to the consumer, so that in effect the consumer can have a very clear understanding of what those options are and make a decision about what's best suited for him or her. Want to add something?
So this is Mark. I just on this a meaningful and effective follow-up. I think we're really interested here in making sure that where there are customers that are using the automated overdraft program over and over and over again, that the institution is engaged in some meaningful and effective efforts to try to, again, as Luke pointed out, make sure that the customer is aware that they're incurring a significant number of fees, and obviously under Reg DD, there's already a mechanism for doing that in periodic statements, but also having an opportunity for that customer to be informed that there are alternatives or there may be available alternatives to the overdraft program if the institution has them, and make it a straightforward process by which the customer can contact the institution to select an alternative. I mean, we don't want it buried in the fine print. Would be an editorial comment there. We expect the effort to be meaningful and effective in informing customers, because we think, absent that, there's some real risk in these programs. So, anyway.
Another question. Do transfers from home equity lines of credit or unsecured lines of credit to consumer accounts fall under the guidance? So as the guidance discusses, one of the alternative products that might be available is a linked line of credit. It doesn't specify what sort of linked line of credit. I think the answer to this question is it really depends on the terms and conditions of the product that would be linked to the overdraft program. Again, this is about a better execution for the consumer, or not a better, but the best execution for the consumer. So to the extent that it's affordable and the fees are appropriate, certainly that's something that could be considered. It really depends on the specifics of that particular product and the particular needs of this particular individual customer.
I don't know if we've done this question or not yet, but it's a short question. So what is the grace period allowed? Have we done that one for the meaningful contact before we must remove an account from an OD program? I think the really important thing here is there's nothing in this guidance that would require an institution to remove a customer from the automated overdraft program. Again, we're focused on the efforts to inform customers of their usage and the alternatives they have, and make that easy to select those alternatives. So again, we're really focused here on the efforts the institutions are making to reach out to their customers and keep them informed, and so there's no requirement there.
Okay. Another question. On page 3 of the guidance, it says, institute appropriate daily limits. What is considered appropriate? This is a question I think that was answered earlier in terms of our presentation, but we do think the guidance discusses appropriate limits, and we do think that that's something that the institution should be focused on. And one example that we give in terms of what might be an appropriate daily limit is 3 transactions per day is an example that may be an appropriate daily limit. An additional question. As an OTS-supervised institution, are we required to abide by the FDIC supervised guidance, or can we still follow the 2005 guidance that was issued by the agencies? First of all, this guidance is FDIC-supervised institution guidance. Was not issued for other regulated institutions. Certainly, if an institution wants to take a look at it and consider some of the pieces of it, that's certainly something they could do, but there's no expectation that that's the case. And obviously, you should have a conversation directly with your regulator as to what systems and processes and policies and procedures you should have in place with respect to your overdraft programs. For FDIC-supervised institutions, one of the key things that our guidance does do is it reemphasizes the key components of the 2005 joint guidance. So we certainly think that FDIC-supervised institutions should avail themselves to the joint guidance from 2005, as well as the 2010 guidance issued by the FDIC focused on automated overdraft programs.
Yeah, this is Mark again. I would just add on to that we really see this guidance as adding, fleshing out some of the pieces that are already in the 2005 interagency guidance, and providing institutions with additional information to help them manage the risks of the automated programs that have been of particular concern.
Another question, have examiners received more specific guidance so that similarly situated banks will be treated consistently? If so, will the guidance be available? Well, we have been very focused on having discussions with our guidance or with our examiners, as we typically do. We have a pretty robust training program here at the FDIC, and we engage our examiners on many levels to ensure that they're focused on the policy objectives that we're working towards. With respect to this particular guidance, we actually have had 2 training sessions with our examiners, which were interactive training sessions with our examiner corps across the entire country. So we were able to field their questions and have a dialogue with them, which we think was very helpful for us and I think very helpful for them. And all of them are focused on ensuring that we're implementing the guidance consistent with the expectations of the FDIC, and certainly that's something that we will continue to do. As you can imagine, as we issue this guidance like we do other guidance, we have a continuing dialogue with our examiners, and as they're in the institutions, they might see something that they want to discuss, and so we have a whole process in place where examiners can engage us if they have questions about implementation of guidance, and we are absolutely committed to applying the guidance consistently across all of our institutions, but keeping in mind the particular risks at individual institutions and the business model at particular institutions. So that's a high priority for the FDIC.
Sure. So here's a rather long question. And it's got a couple of different facets to it. A consumer has 6 occasions within a 12-month period. Have we done that? We don't think we've done that one yet. 6 occasions within a 12-month period. He has been counseled in some meaningful fashion. In the months that follow, he has another occasion. I assume that means an occasion where they overdrafted. Accordingly, he may have another 12-month period in which he's had 6 or more occasions. How many counseling attempts are we required to make? Is there an official suggestion on how to respond to customers who tell us that how they handle their checking account is none of our business? I wanted to raise that question in part because that's one of the things that I've heard a great deal from bankers is this fear that our guidance or that our examiners in particular were going to have an expectation that the banks were going to harass their customers and contact them over and over again on these overdraft programs, no matter what the customer says is their preference. As we've said, I think throughout this call, I think our expectation and our hope is that the banks will, institutions will undertake efforts to inform customers of their usage of the overdraft programs, what the alternatives to that is that may be either lower cost or better suited for their needs for short-term credit. At the end of the day, it's the customer's choice. And if you have a customer that you've had some discussion with, as we talk about under the targeted outreach approach, if you've had that kind of conversation and a customer says, thank you very much, but this is none of your business, we would expect institutions to respect that choice by the customer. So we don't have the expectation there that you've got to do something extra, just based on this guidance. Similarly, I think, one of the things we've tried to do on this call, and we'll have this in our written question and answers, is we have a couple of specific illustrations on how we think an institution can meet our expectations around meaningful follow-up. Those illustrations, the question deals with the targeted outreach program. We also have an alternative illustration that deals with ways that an institution can enhance its periodic statements to call attention to overdraft usage above and beyond what's in Reg DD to make sure that institutions are informing customers of, again, alternatives to overdraft and maybe an easy way to contact a customer service representative. And those are just, and we're providing that as illustrations. At the end of the day, we're not bank management. Bank management is bank management. And, we hope institutions that these specific illustrations are helpful as, giving examples of what can satisfy the expectations that we have as the regulator here. But banks may have alternatives and develop innovative ways to demonstrate meaningful and effective follow-up with chronic users of Overdraft. I think the real key question is that make sure that it's meaningful and make sure that it looks effective. So that's a long-winded answer to that question, but it's a long question. So let's see, do we have other questions online?
Okay. Here's a very helpful question. Since the overdraft guidance was subject to the notice and comment provisions of the Administrative Procedures Act, similar to other rulemakings, how does this differ from a rule with regard to enforcement or otherwise? So, again, this is not a rule, it is guidance. And the FDIC elected to post the guidance in public so that various stakeholders, whether they be financial institutions or advocacy groups or consumers or anyone that might have an interest in this guidance or an interest in helping us refine the guidance to improve the policy, would have an opportunity to do that. So we did do that. But this is not a rule or proposed rule or notice of proposed rule. It's guidance. And the extent that we posted it for public comment, that was not pursuant to the Administrative Procedures Act. I think as was discussed earlier, if an examiner is an institution and they identify an issue, they might note it in their exam report. And if there's a violation of the law, certainly there could be some sort of enforcement action as is appropriate, but any action taken would be consistent with the law, and that will be our approach. Another question, do we actually have to document the discussions with customers, or will a written policy or procedure and how and when those discussions are conducted be sufficient? Any examination that takes place will be like our typical examination. So I can't specifically answer that question in terms of what specific record keeping there should be in place or what specific documentation should be retained by an institution. But what I would say generally is the extent that examiners will be coming into your institution, they will be making requests for information, and you should document what you've done as is appropriate to indicate to the examiner that you are acting consistent with the expectations of the guidance. So whether that be policies and procedures, which certainly we would recommend that policies and procedures be put in place that address some of the key risks identified in the guidance. That's certainly something that should be in place. Training is something else that could be done of institution employees if that's deemed appropriate, particularly any employees having discussions with consumers about alternative products. And any sort of other ways to document to the extent that the follow-up is meaningful and effective and that alternatives are offered, I think certainly would be helpful for examiners as they're reviewing the institution, and certainly to the advantage of the institution to the extent that they're able to document what work they've done in this area. Additional question, will the FDIC force banks to offer account transfers or lines of credit for overdraft purposes if banks do not currently offer either alternative? The answer is no. There is no expectation that an institution should create new products that don't currently exist for their customers. However, we do believe that most institutions have either lines of credit or other products, small dollar loans, that are other options for consumers that consumers may want to avail themselves to that would be helpful for them and better suited for them in some cases, but there is no expectation that a new product be developed by an institution and that product be offered to any consumers.
You want to go ahead and I'll take one. So these two kind of go together, and just to make sure we've covered this ground. We cannot reach the customer should we remove them from the OD protection program. I think we've mentioned before we don't have an expectation that institution is going to remove someone from a program. We do expect the institution to undertake meaningful and effective follow-up to inform consumers of their overdraft usage and alternatives, as I mentioned. Similarly, how should a bank handle overdraft fees that occur during the interim period of time from when the consumer exceeds 6 overdraft fees, but the bank has not had meaningful contact with the customer? I think what we are hopeful is that if an institution is engaging in targeted outreach programs as a way to follow up with customers, that after the consumer has more than six overdrafts, that the institution will move quickly to reach out to that customer. But there's no implication there that they should take an action regarding the account in the meantime. So that really goes to, have there been meaningful and effective efforts to follow up with customers, and obviously that's something that the examiner is going to be looking for and understanding how you're operating that program and what you're trying to do to reach those customers.
Okay, I have another good question, which I think Mark probably will have something to add to this. Do the statements made by the FDIC personnel during this teleconference bind the FDIC and its interpretations offered to individual financial institutions by its field examiners? So the purpose of this call is to provide helpful clarifications on the guidance that we issued back in November, and to answer the frequently asked questions to the best of our ability. Our answers to these questions are basically staff answers and interpretations of the guidance, which I think will be helpful to you as you go back to your institutions and attempt to implement the guidance and work through the issues. So we hope that we find that you find them helpful, but this is not a call where we're specifically walking through technical requirements under some sort of rule or regulation.
Yeah, this is Mark. I mean, I think the thing that you'd want, I think institutions should expect that what they're hearing today from us is going to be consistent with what they see out in the field when they go through an examination. And obviously, if for any reason that happens not to be the case, we certainly have a number of different ways you can help inform us of that. As Luke mentioned earlier, we've undertaken a great deal of communication with our examiner workforce on this issue to walk through the guidance, talk about our expectations, and the flexibility that institutions would have to meet those expectations, and that this is part of a holistic supervisory approach around these programs, and it's not a check the box kind of did you do what's on page 2, third paragraph, number 6, right? So that's our approach to this effort, and we certainly want to make sure we're consistent in how it's applied here. What you're hearing here is happening out in the field.
An additional question. This is similar to some other questions, but I think it's helpful as well. As there are many, many important issues to our bank and consumer protection in general, why does this issue merit an annual review by the board when there are so many other issues? Well, I think a number of us have talked about the risks that we've identified with respect to these programs. We don't have an expectation that boards of directors should be managing these overdraft programs within the institutions, but what we do think should happen is they should at least be informed at some point during the calendar year of the key components of the program, because there are reputational and compliance and litigation and safety and soundness risks potentially with respect to these programs. And obviously, to the extent that there are risks to an institution, board members should be aware of that risk, as is appropriate from where they sit as a board member, but we do not have thoughts about board members managing the program.
I think we're getting close to the end, Luke.
Okay.
Is that a good stopping point?
Well, I have maybe one more question. Do you have
Let's fit one more in the wire, and then we'll maybe wrap up.
Here's the final question, and Mark might have some closing thoughts. The bank does not promote overdrafts. How would it train staff to explain program features if it is chosen not to induce consumers to overdraw their accounts by explaining its decision-making process on overdrafts? I would just say the answer to that question is that the way our guidance is structured, it's not focused on promoting overdrafts. It's focused on whether you have an automated overdraft program in place and ensuring that the portions of that program, the requirements of that program, are consistent with our guidance to prevent risks. So that's the way that one should think of their program, not with respect to whether it's promoted or not promoted, but they should focus on the fact that they offer it, and if it meets the definition of automated program, the excessive or chronic use components of the guidance does apply to the program.
Great. Thanks, Luke. And I want to thank Victoria and Michael for helping put this for putting this presentation together and answering the questions that we've received as part of this guidance. I guess in closing, I hope this call has been helpful and provided you with some information and insight into our approach with the guidance that will help you manage the risks of the automated payment, overdraft payment programs. To recap, I mean, I think it's important to recognize that there are real risks in these automated overdraft programs, especially around chronic or excessive usage. And we think we encourage institutions to engage in meaningful follow-up for that 10 or 11% of their customers that are having more than 6 overdrafts in a year, to make sure they're aware of what the costs of those programs are and whether there are alternatives out there. And we would hope that we believe from our research that most institutions have some alternatives that might be better suited for customers, and we want customers to have an easy way to choose those programs if they're available. So that's really our primary goal through this process. We have today on this call some in our guidance back in November, today on this call, and we'll have this in our written frequently asked questions, is we have a couple of different illustrations to demonstrate ways in which an institution we believe could demonstrate effective and meaningful follow-up with their customers, but those are not exclusive. There are other ways in which institutions can demonstrate their efforts to reach out to their customers, and we think we encourage institutions to do that. That's consistent, we believe, with what the purposes of guidance is in the regulatory world, and hope you take it as important issue for your institution to look at what risks you have in your program if you are offering an automated program, and hope this is helpful in managing those risks. I think we've covered a lot of questions and answers today, and I want to thank also the institutions and their trade organizations that have really engaged in, for the most part, a constructive dialogue over the past few months as we've tried to think through different ways that institutions were able to meet the expectations in the guidance and some of the concerns. We tried to work through this call to help clarify and hopefully address some of the misperceptions and confusions that people have had about the guidance. So we'll, in closing, I guess, look for a written document from us up on our website by the end of this week that will have some of the written answers to these questions. If you had questions that you didn't hear the answer to today, you know, and you still, this call has not answered those, we still encourage you to send those in, and we can, you know, see if we get enough questions on a particular issue, then, you know, we'll see how we can provide supplemental information there.
Yeah, the mailbox is still open.
And I think that's in the fill. I don't have the address right in front of me here, but in the original fill we had it. So, yes, so someone, so it's odcallquestions@fdic.gov. So odcall, C-A-L-L, questions@fdic.gov. So anyway, I appreciate your attention for this call, and sorry we ran a little late on this one, but hopefully this was informative. Thanks.